A slew of lawsuits where plaintiffs have asked the U.S. Supreme Court to review and rule on their challenges to gun laws have been relisted. And all this comes as activity in lower courts is signaling what could be coming down the pike in other states. Welcome back to the States. I'm your host, Greg Bishop. Be sure to like, subscribe, and hit that notification bell for the latest. As we look at what happened in the U.S. Supreme Court today, the last day scheduled for the year when it comes to releasing the list of which cases they're going to take and which cases they're not going to take, or which cases we're still uncertain what's happening with them. And while they did release a long list of cases that they denied to take up, and a few cases they said they will take up, and even ruling on some, you've got a slew of Second Amendment type cases. And one in particular, issue that's being dealt with in some of these cases that are lingering, is just how old somebody can be when they purchase a firearm and how long they have to wait to be able to get that firearm, be it from 18 to 20 or 3 days waiting period for certain firearms. There's a slew of cases dealing with that question of 18 to 20-year-old adults and whether they can get a handgun license or whether they can carry firearms or whether they can purchase handguns, including cases like Bivens versus the Second Amendment Foundation. That's challenging Pennsylvania's ban on the right for 18 to 20-year-olds to carry firearms. You also have McCly versus ATF. You have West Virginia Citizens Defense League versus ATF. That's a Second Amendment lawsuit that's still lingering in the U.S. Supreme Court, challenging the federal ban that prohibits adults aged 18 to 20 from purchasing handguns and ammunition from licensed firearms dealers. You also have Pecan versus United States, another challenge to laws restricting 18 to 20-year-old adults from getting handgun licenses and carrying firearms. So all of the cases there were relisted, but when are they going to actually release a new list of cases they take up? It's not scheduled on the U.S. Supreme Court's calendar for the rest of the year. While they have conference later this week, whether or not they're going to announce which cases they decide to take or which cases they continue on to the next U.S. Supreme Court term has yet to be seen. So a lot of people still scratching their heads wondering what's going to happen with these particular cases. Now, there's other gun control cases that are being challenged that the U.S. Supreme Court has not shown their hand as to if they're going to take those cases, including ones dealing with drugs and firearms, despite a similar case having had a ruling last week. Now, other cases that are still floating out there when it comes to the Second Amendment in the U.S. Supreme Court deals with Cook County's gun ban, which also challenges the state of Illinois' gun ban. That case, Veramontes v. Cook County, still there and being relisted for a Supreme Court conference later this week. But again, we don't know when the Supreme Court is actually going to be releasing that orders list, because they had one scheduled for today and there's no more scheduled for the rest of the year. Now, no more conferences. We'll see possibly if they decide to announce one. It's difficult to determine the court's schedule, as that's kept very close to the Supreme Court. But there are other cases out there in the judiciary, including Barnett v. Raoul, that remains in the Seventh Circuit Court of Appeals, challenging Illinois' gun and magazine ban that was enacted over 3 years ago. That case, which was heard last November, still pending in the appeals court. Meanwhile, a Virginia judge denied a request late last week to temporarily block that state's new ban on certain types of semi-automatic firearms, leaving the law on track to take effect July 1st, while a lawsuit challenging that bill moves forward. The Center Square reporter, Charlene Guerrera, reports the judge denied a preliminary injunction in that case, Curtis v. Katz, a case brought by gun rights advocates challenging the law under the Virginia Constitution. Now, the judge acknowledged the plaintiffs could be harmed if the law is later ruled unconstitutional, but said they did not meet the legal standard required to temporarily stop the restrictions from taking effect. Now, the lawsuit argues the law violates Article 1, Section 13 of Virginia's Constitution by preventing citizens from owning firearms, and the plaintiffs say are protected under the state's militia clause. But the judge disagreed at this stage. He wrote that it's currently persuaded that both the history and practice surrounding Section 13 establish no right for the individual to possess military-style weapons by members of the unorganized militia. This means the judge said that he does not believe Virginia's militia clause creates an individual right to own military-style firearms. Now, that question about military-style firearms was brought up in the case Barnett v. Raoul we mentioned earlier out of Illinois. You had the courts in the past saying that they needed answers from the litigants as to what exactly is a military-style firearm, and are these commonly owned firearms that are semi-automatic rifles considered military style. And there was a 4-day bench trial in Illinois. The Seventh Circuit Court of Appeals now having that after they heard it were still uncertain. But back to Virginia, Attorney General Jay Jones, the state's Attorney General, he said that the court's decision in Curtis v. Katz is an important step in ensuring that Virginia's assault weapons ban will go into effect July 1st. He further said in a statement, the Commonwealth will defend against any appeal in the case and will continue to defend the assault weapons ban in every case to keep Virginia safe. Now, meanwhile, the Attorney General held a news conference just this morning about enforcing a separate law that could get challenged in the courts, the Firearm Industry Accountability Law. Here's the Attorney General from this morning.
This law simply says that no industry should be immune from accountability when its actions contribute to public harm. This is not anti-gun. This is pro-safety. This law reflects a simple principle. When gun industry actors act negligently and cause harm through irresponsible or unlawful practices, they should be held accountable. Accountability is not a radical idea. Accountability makes up the foundation of our legal system. We expect accountability from individuals, we expect accountability from our government, and we should expect accountability from industries whose decisions have impacted and affected the health and safety of those that we love and hold so dear.
Now, Jones had support from Virginia Delegate Dan Helmer, saying if local authorities won't enforce Virginia's gun laws, he says the state will.
What this House bill does and the accompanying Senate bill is ensure the Attorney General has the authority to hold anybody who acts irresponsibly accountable. So for those who are saying we're going to defy the law, you're going to be held accountable. You may be held accountable by your local Commonwealth's attorney and your local sheriff. And if not, I feel very confident that the Office of the Attorney General will hold you accountable. Our communities, our children deserve to be safe. And this suite of firearms safety measures ensures that we promote responsible gun ownership in the Commonwealth. We have no truck with those who, I'm a gun owner myself. I have no issue with somebody who wants to responsibly own a firearm. On the other hand, if you act irresponsibly, if you make our communities less safe, if you sell to straw purchasers, if you manufacture ghost guns, if your guns constantly are found in crimes, well, we now have a new tool.
Now, again, this gun industry measure looking to go after gun sellers or manufacturers seems to have been bolstered by a case out of New York challenging a similar law out of New York being denied on cert, and that's the request for the Supreme Court to take up, challenging New York's law, and that seems to bolster the Virginia law. Again, here is the Attorney General talking about that very issue.
Certainly, New York was a great moment when the Supreme Court denied cert. We feel very confident in this law and how it has been structured and how it will be construed by the courts. Again, this is about public safety. This is about accountability. Nobody should be in fear in their communities, and we just want to make sure that the playing field is level.
Now, Jones, he went on to further say they will enforce Virginia's laws and defend them. You can expect a lot more reporting at the Center Square on all of these stories and more. Be sure to get the newsletter at thecentersquare.com.